In continuation of our discussion looking at various different aspects of company decision making, I want to spend some time in this lesson thinking about the rules associated with notice of board meetings, because this is part of the rules that we see in Part 9 of the Model Articles of Association, and it is the provision for governing the notice of a director's board meeting. To really understand this properly, we need to get to what the rules actually say, and then how many commentaries and how it has been broadly interpreted as we see with things relating to issues concerning things like reasonable notice, for example, and what happens where there may be the issuance of a waiver of notice, or maybe where there is defective or insufficient notice of a board meeting, what happens in those kinds of circumstances. So we're still talking about company decision making and meetings, the sort of procedural disclosure and approval requirements, and Model Article 9 is where we're going to be focusing our time, Part 9 of the Model Articles. Rules concerning directors' meetings are found really quite broadly in Parts 9 to 13 of the Model Articles. Part 9 is concerning our lesson specifically because we're going to be focusing on the notice of board meetings, but other parts of the rules that govern directors' meetings are found in Parts 10, Parts 11, Parts 12 and Parts 13 as well. So we will get to those in future lessons too. So, like I said, we're going to begin with Article 9 of the Model Articles in this lesson, and Article 9 is very, very simple. It says the following. It says that any director may call a directors' meeting by giving notice of the meeting to the directors or by authorising the company secretary, if any, to give such notice. Of course, not every single corporation has a company secretary, but the ones that do can be utilised for the calling of a directors' meeting. Within this, then, any notice of any directors' meeting must indicate, firstly, its proposed date and time, secondly, where it is to take place, thirdly, if it is anticipated that directors participating in the meeting will not be in the same place. So, for example, if there is some kind of large corporation where maybe some of the directors might be out of the country, or maybe some of them have just gone on holiday, then how it is proposed that they should communicate with each other during the meeting. So, how they are to communicate, i.e. arrangements for things like remote communication, something that is obviously a lot more common these days anyway. Within this regard, then, Part 3 of Article 9 refers to the rules concerning that the notice must be given to each director. Each director of the corporation has to be given notice of a meeting that they are expected to attend. The notice need not be in writing. It could be given by other means, unless the articles explicitly require that a notice is given in writing. And a director may waive their entitlement to notice if such waiver is given to the company no more than 7 days after the meeting. Then notice need not be given to that specific director. We'll get to waivers in a second. But what we might notice straight away, pardon the pun, is that Article 9 provides a framework that is relatively flexible. It sets a certain minimum level of content requirements, so the date and time, where it is to take place, and how a person is to be able to communicate within the meeting if it is anticipated that they would not be in the same location. Those are the sort of minimum requirements for notice, and requires, of course, that this be given to all directors. But it does not rigidly demand a fixed period, nor does it specify a formal method, leaving a certain sense of flexibility in order for members of the corporation or the corporation itself to adapt to circumstances and to adjust by article amendments. Within this, then, because the Model Articles do not prescribe a fixed notice period, one of the key questions that might be asked is what amount of notice is required. And within this context, the standard phrase that is used, that essentially reasonable notice is required. Well, how is reasonable notice interpreted? Well, The phrase is often used in the commentaries and all these different kinds of things to try and fill the gap that is left by the model articles. This idea of reasonable notice, that is, notice that must be given in time sufficient for the directors to make arrangements and make their preparation. And so reasonable notice itself is very, very flexible. Broadly speaking, is defined as an amount of time that is sufficient for a director to make these kinds of arrangements and to prepare for the meeting. And so because it is relatively flexible, it is dependent on a variety of different factors. You have a number of factors, including things like the nature of the business to be transacted. So maybe urgent matters might justify shorter notice, for example. That's an illustration that we might see there. The location of the directors. If some of the directors are abroad, then this might, in quite larger, often international corporations, be an issue that needs to be considered. Although, of course, the means of how to get communications is still listed in Article 9. So it might be the case that electronic communications is important, but also it could be included the usual practices of the company. How has past notice practices been operated? What is the sort of general time that is being given to previous notice requirements? And so how does that inform how we as a company sort of interpret reasonable notice for our directors, for our members? And then also, of course, how quickly decisions need to be made. In emergency situations, maybe there might be an even shorter amount of notice. In terms of thinking about waiver of notice, I want to just provide you with a little bit of insight into Article 9.4 of the Model Articles of Association. It says here that notice of a directors' meeting need not be given to directors who waive their entitlement to notice of that meeting by giving notice to that effect to the company not more than 7 days after the date at which the meeting is held. Where such notice is given after the meeting has been held, that does not affect the validity of the meeting or of any business conducted at that meeting. And so essentially what this is telling us is that a waiver must be given. If a waiver is sought out to be given, then it must be given to the company no more than 7 days after the date of the meeting. If later, then the waiver still does not invalidate the meeting necessarily. And a waiver essentially means that the director loses their right to complain about being insufficiently notified of the existence of a meeting, so that the meeting and its decisions are not invalidated automatically by simple virtue of the fact that a single director might lack some kind of notice. And it's to sort of provide for the circumstances in which, let's say you've got quite a complicated business, you maybe have a number of different directors that are all in different parts of the world, some may be unable to be communicated, and so they would allow their notice to be waived, and in order for that to be the case, such that if there's a situation in which they do not have sufficient notice for whatever reason, that the decisions that are made at that board meeting aren't automatically invalidated by that fact. So waiver of notice is included as a way of sort of, again, providing a certain sense of flexibility. But what if there is just insufficient notice? What if there hasn't been a waiver of notice? What if there is just defective, insufficient, or a non-notified director? What happens in those regards? Well, in those kinds of circumstances, what happens if there is an inefficient amount of notice or a defective amount of notice? Then it might be argued that the meeting is invalid, that is specifically invalidated, and that a new meeting, a fresh meeting, needs to be convened. So, for example, older authorities suggest that a director not given proper notice may demand that another meeting be called within a reasonable time, and so that provides you with some kind of insight into what could happen in that circumstance. Alternatively, a more practical approach can sometimes be taken, and the courts sometimes do take those kinds of approaches. Let's say, for example, if notice is insufficient, but it does not negatively impact the decision of the directors or the directors themselves. Well, in that kind of circumstance, then, this sort of strict rigidity is loosened, the point at which maybe the decisions could still be upheld, the decisions could still be valid, even if notice is insufficient, just because insufficient notice does not necessarily mean that it has negatively impacted the decision at the meeting or the decisions on the part of the directors. Since the articles permit waivers as well, as we've already noted, directors may lose their right to challenge the sufficiency of notice that is given by accepting or acquiescing by way of some kind of waiver as well. And so really, in short, in summary, a failure of proper notice does not automatically prove fatal for the particular decision itself, but it is a basis that could be given for a director to challenge said decision-making process.